Thank you. Please be seated. Good morning. This is 1 CACV 180513, Mashni versus Sunnyslope. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal, if desired, and counsel for appellee may reserve a portion of the time for rebuttal to address only the cross-appeal issues if desired. Also, we have read the briefs and we have discussed the case in conference. Counsel, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Kristen Arredondo, and I'm here with my colleague, John O'Neill. We represent the appellant and cross-appellee court-appointed receiver, Paul Mashni. The receiver is here today appealing the Superior Court's outright denial of 2 out of 4 fee applications that the receiver submitted over the course of several years in this receivership matter. The Superior Court properly granted applications 3 and 4 in full, but the Superior Court's decision to grant 0 of the fees requested in applications 1 and 2 was based on an incorrect legal conclusion. Had the court applied the correct legal standard to the fee applications 1 and 2, it would have granted most, if not all, of the fees requested in those applications. The receiver's entitlement to fees is governed by the express terms of the appointing order in this case. Section C8 of the appointing order authorizes the receiver to recover fees, attorney's fees, that are necessary to assist him in the discharge of his duties. The receiver's duties under the appointing order are broad. This court has noted that in both prior appeals, Mashni 1 and Mashni 2, that the receiver's duties are broad under the appointing order. Sunnyslope never objected to the appointing order, and it never sought to modify or otherwise limit its scope.
What about, counsel, what about your colleague's argument that something might fall under the 4 corners of that order, but not have been spent to benefit either the bankruptcy or the receivership estate? I guess my first question is, would those monies qualify for a fee payment? And I guess I haven't really thought it through, but if they didn't fall within the 4 corners of that delegation, so you have Mashni hiring counsel that he, I think it's believes is needed to discharge his duties, but it's not to benefit the bankruptcy or receivership estate, are those fees available?
Well, I think that Sunnyslope has taken a very narrow view as to what it means to benefit the estate. The receiver acts for the benefit of, as in on behalf of the receivership estate. So I think the standard is fees that are necessary in carrying out his duties. So there may be a circumstance where the receiver's attorney's fees don't necessarily have some proven tangible benefit, like increasing the assets of the receivership estate, but they were still authorized conduct under the appointing order that the receiver...
Well, let's say it's authorized conduct and it actually works to the detriment of the estates. Should he be awarded fees for that?
I think it depends on the circumstances of the case, but if it was in his official capacity and necessary in discharging his official duties under the appointing order, they would be awardable.
But isn't there discretion on the part of the trial court to decide how much of it actually benefited the estate? And couldn't you make a determination that 5%, only 5% of what you did actually benefited the estate? And if you get to 5%, can you get down to 0?
I don't think the court could find that 0 of the attorney's fees requested were unnecessary and unreasonable in carrying out the receiver's duties. And certainly it would have benefited the estate for the receiver to conclude the receivership and be discharged from his duties. And he tried to do that back in January of 2012, and Sunnyslope prevented him from being discharged and pursued claims against him that were in his official conduct under the appointing order. And we know he was sued for his official conduct because this court held in Mashni 1 that the receiver's actions were taken under the express terms of the appointing order.
So is the crux of your argument that it was error because it was zero?
Yes.
Let's say that the court peeled off 10,000 from the third and fourth and attributed it to the first. Would you still have your argument?
If I think that it would be a different situation if the court had looked at all 4 applications and said, after reviewing the application 1, I think this amount is reasonable and necessary for the receiver in discharging his duties. But there were 4 separate fee applications for the court to consider, and the court did consider them as separate applications and just declined to even consider applications 1 and 2 and awarded nothing under those.
Is the court allowed to sort of take them together, though, as 4 and look at a sort of a discrete figure that it thinks is reasonable and allot among the 4 what it awards, but doing so each tethered inextricably to the other?
A court could certainly exercise its discretion in a way it finds appropriate under the circumstances, but here the court did consider them as 4 separate fee applications. The parties have treated them that way, and our appeal only appeals applications 1 and 2, and the court's decision to award 0 for that. And when you look at what the Superior Court did here, it simply adopted Sunnyslope's argument that the court was just bound by the previous trial judge, Judge Foster's denial of those 2 fee applications back in August of 2013.
But assuming you're not bound by it, do you see any problem with relying on the underlying logic or the discussion that Judge Foster conducted?
Yes, I do, because this court in Mashni 1 reversed Judge Foster's order, and when you look at Judge Foster...
Didn't it only reverse as to whether there was immunity?
Yes, so the court only expressly vacated and reversed Judge Foster's immunity ruling, but when you look at the immunity order, immunity is the only thing that Judge Foster even discussed. He talked about Sunnyslope's allegations of misconduct and stripped him of his immunity and granted Sunnyslope leave to file a complaint against the receiver. And in connection with that ruling, he also, without any discussion, also denied the receiver's request to be discharged, and in connection with that, denied his request for attorney's fees and costs in those 2 fee applications.
Well, was Judge Foster's ruling predicated on an assumption that the receiver was acting outside the scope of his responsibilities, or was it just that there's no immunity even if you're acting within the scope?
To be not immune from suit, he would have had to have been acting outside the scope of his authority. So yes, Judge Foster's ruling was predicated on his opinion that the receiver wasn't acting within the scope of the appointing order.
But didn't you, in your special action, raise 2 discrete issues? Immunity and an application for fees. And if you look at this court's order, it says we vacate the Superior Court's ruling denying Mashni immunity from suit and remand this case for further proceedings consistent with this opinion, period. Mm-hmm. In the exercise of our discretion, we decline to address the remaining issues raised in Mashni's petition for special action. So isn't that saying that we didn't address the fee issue? And would we even have jurisdiction on a special action to address a fee issue in the middle of ongoing receivership, Right.
It makes sense that the court didn't address the fee issue. It would have been premature. The immunity order was granting Sunnyslope leave to file suit against the receiver. And at that point, because leave was allowed to sue the receiver, there wouldn't have been a discharge and a final determination of the attorney's fees. So those were just tied to the immunity order, and this court didn't affirm the denial of the attorney's fees, just declined to consider the other issues.
So how did Foster's ruling lose its force and effect? At what point? If we left it intact and untouched, presumably it lived,
Right.
and then when does it?
Well, back on remand after Mashni won, the receiver renewed those first two fee applications. And then at that point, it was the second judge, same court, but second judge, Judge Gerlach, considered and ruled on the receiver's renewed request to be discharged from his duties and for an award of his attorney's fees under applications 1 and 2. So the court considered them. Judge Gerlach ultimately denied them for an improper reason and was reversed by this court in Mashni too. But the court ordered the Superior Court to consider and rule on the fee applications. So I don't think that Judge Foster's previous denial stood any longer, and the Superior Court couldn't have relied on that as a legally valid reason to simply decline to consider applications 1 and 2 and to deny them.
Let me ask you, let's say Judge Gerlach stopped typing after those first 2 sections that he talks about. He says that the fees are not reasonable, and he uses another adjective. Before he pivots to mootness and whether this is the right place. If he had stopped right there, would you have any appeal?
Well, I don't know what his ultimate order would have been if he stopped there. He did note that he believed that around 15% of the receiver's attorney's fees, and I'll note that Judge Gerlach took issue with the receiver's request for his own compensation, which is no longer at issue and has been dropped. He's only seeking to be reimbursed for his attorney's fees. So I don't know what amount that Judge Gerlach would have found was necessary and reasonable, but he was also relying on improper legal standards and discussing bankruptcy standards. But the appointment order in Section C8 is what governs the receiver's entitlement to fees in this receivership action. I'll also note that under Arizona law, the party requesting fees bears the initial burden of setting forth the entitlement to fees and the affidavit and time entry setting forth the reasonableness of those fees. But once a party chooses to object to that fee application, the objecting party bears the burden of pointing out with specificity which fees are not compensable or not reasonable.
So are you arguing that there's actually a legal error in Judge Contes' opinion, which is that she seemingly denied fees for a reason that wasn't valid, which is attorney's fees not spent in furtherance of the bankruptcy or receivership estate. So that's a question of law, and this court, without looking for the reasonable basis in the record, can just saying that's not accurate. Is that your argument?
It is our argument that the Superior Court made an incorrect legal conclusion in adopting Sunnyslope's argument that Judge Foster's decision remained valid and
Right, I'm talking more about Gerlach, right? You had said just a second ago that Gerlach had some discussion, which turned out to be dicta, but that it's not being expended in furtherance of the receivership and the bankruptcy estate, and I thought had just said that was wrong.
Oh, right, that is wrong.
Okay, and so didn't Contes say something very similar, almost parrot the language in her order, and are you arguing that is a legal error?
The language about preserving the bankruptcy estate?
And Contes is, right,
yes,
that she
that would
plucked
be,
from Gerlach.
Yes, my apologies. Yes, that would be a legal error because the standard governing the receiver's attorney's fees here is governed by Section C8, those that are necessary to assist him in discharging his duties under the appointing order. And this court has noted in Mashni too that Sunnyslope has only ever vaguely objected to the attorney's fees as excessive or unreasonable, but it has never, at the court below or even before this court, pointed out and specified which time entries that it's objecting to. So under the circumstances of this case, we would ask that the court reverse the denial of applications 1 and 2 and remand with instructions to grant those applications in full. And I'd like to reserve the remainder of my time for rebuttal.
Thank you.
Morning, Justin Henderson on behalf of Sunnyslope Housing Limited Partnership, and may it please the court. Excuse me. The fundamental problem with the receiver's argument is he's conflating entitlement to fees with eligibility and not really proving either of those. The receivership order does not abrogate the American rule and allow the receiver to recover all of his fees just because he is the receiver.
But here there was a recovery of 0, and there's been a finding that he was acting within the scope of his duties. Doesn't that suggest that how can you award 0 if the actions were within the scope of his duties?
Well, in Mashni 1, the court noted that even if a receiver acts in bad faith and is doing bad things, he's still entitled to immunity if he's acting within the scope of the appointment order. But I think what Judge Foster found is that the receiver was engaging in misconduct. He then took that the next step.
Was there a finding of misconduct?
I believe so. He said that he was not fairly discharging his duties.
But what's the misconduct? What is there a specific finding of misconduct?
I don't know that he identified the particular things, but it's what we've been talking about in this case from the beginning, which is the refusal to honor the restrictive covenants, and then after that, communicating with the state and saying, oh, these aren't, the tax credits don't apply anymore, which the bankruptcy court said appeared to be an attempt to exercise exercise dominion over property of the estate. There was also the insurance proceeds.
But that's not a finding of misconduct. The bankruptcy's comment that it appeared to be, as you just stated.
There was no firm root. The bankruptcy court left the automatic stay issues to the trial court here.
Okay, so let me ask you, counsel. So what if the receiver has to defend actions that arguably benefited the estate only because the debtor in possession disagrees with the receiver's approach? Aren't we implying here that the receiver acted to the estate's detriment, even though there's not been a finding?
Well, I think that what we need to look at is I don't know that the trial court judges weren't required to make any findings, and I think that really what's in the record is what matters the most. But I think that
so we should reach a conclusion of misconduct?
I don't think you need to. I think all of the evidence in the record shows that there was misconduct. That's also just one piece of it. All of these fees are all related to one another. It all stems from this initial charge of misconduct, but there's also significant fees for trying to get fees.
Well, but don't all the fees come from conduct which the receiver was permitted to engage in?
No, I don't think so. I think
he
was entitled to
immune from being.
He had immunity from liability. That's entirely different from whether he's able to then fee shift, effectively using that immunity finding to justify the granting of the fee application, and thereby sort of profiting from the very misconduct that we were complaining about from the beginning.
So don't you have to take it one step further and establish the misconduct? I mean, so I understand your point is that immunity does not give him the ability to then engage in misconduct, but then don't you have to establish the misconduct separate and apart so that you can preclude him from benefiting from it?
I think that it was established and that Judge Foster did talk about the violations of the restrictive covenants, and that was one of the primary examples of misconduct that the receiver engaged in. Again, he's immune from liability, but that doesn't mean that he's able to shift fees.
So your position is that that portion of Judge Foster's order stood?
Yes. When Mashni won, as the court said just a minute ago, when it remanded, it only, well, first of all, it declined to address points 2 and 3 in the special action. 3 was the attorney's fees issue. So it was remanded. The court did exercise its discretion. It specifically says we're declining to, or exercising our discretion, and we deny fees.
So counsel, I hear you saying that we have almost 2 fields of play. We have one field that is this immunity field, and was resolved in Mashni 1, I think it was. And then we have the second field, which is what fees can be paid from what Mashni did. But is there really this duality, this binary field, option A or 2? Because I'm looking now at Mashni 1, and it says immunity, this is what it turns on, a receiver may therefore be liable to interested parties for harm caused by deviation from the order of appointment. So the immunity holding seems to say, as long as Mashni remains within the 4 corners of that order, he is immune. Now let's shift to that second field. How does that differ? You must be arguing that he can do something that falls within the order of appointment, but still not get his fees?
Right. And so I think there's any number of things that a receiver could do that falls within the scope of the orders. And say that he had 100 executory contracts and they were all very valuable to the estate, and he just went in and rejected all of them without considering what the effect would be on the estate. He may still be acting within the scope of the order, but acting in bad faith means he doesn't get fees. He doesn't get fees because it does not benefit the estate. If somebody sues him, he's defending himself personally. That's what all the case law says.
And that would be consistent if, for example, he accepted an offer or offered to sell the property for $10.
Right,
That's
yeah.
within the scope of his duties, but we would say that's not something that benefited the estate and not compensable. That's your argument.
Precisely.
So then the test to get fees is almost like a 2-part test. First, it has to fall under the terms of the order, which is Mashni, I think the word is needs, or feels the need to retain counsel, part 1. And part 2 of that test is what? That it benefits
The estate.
And which estate?
Receivership estate.
Okay. And is there a case or a statute that you can provide for that point?
Well, I think that the burden for providing a statute is on them. I don't think there is one. And that's my point at the beginning, is they're conflating eligibility, which is, I think, twofold here. I think you're right that it is, you have to look to the receivership order to see what he's authorized to do. By the way, he wasn't authorized to defend himself in any actions. He could have come back and gotten an amendment to the receivership order that expressly allowed him to defend himself and pay himself out of the receivership estate.
At what point did your client object to any of the fee requests or specified this amount is unreasonable, or was it just an objection to the entire amount is unreasonable?
No, I think if you look at the briefs, we do cite to where we're objecting to particular things, but the problem with evaluating this fee application is what I alluded to earlier, which is all of the fees are lumped together. And there's big chunks of block time. There's big chunks where we can't even tell what they're doing.
Separate out block time. Just
Right.
an argument that you're entitled to 0, and that was made the argument that nothing that he's done has benefited the estate.
Yes, and that would have been after the final fee application was filed. We and Judge Contest referred back to our objection, where we said there was no benefit to the estate, also referenced the block billing and time entries. We can't tell what they're for. and the fact that this is all blended together and should be just denied out of hand. I don't think there's any case law, particularly on the fees to get fees. They're asking for over $400,000, and a significant chunk of that is their attempts to get fees. Mashni, too, that's what that entire case was about. And every case says you cannot get fees for preparing a fee application or defending it because you're benefiting yourself personally. And then the third chunk of this is the 2 prior court orders from this court declining to award fees. So all of that is wrapped into these fee applications.
But those were on appeal.
Right.
And those expressly declined to address the merits of the fee application.
That's right. That's right.
So I just want to be hammer down the standard. Are we to assess whether there is a reasonable basis? How much was requested in the first and second?
I don't recall the
200 something? Okay.
Maybe a little less than that.
So is the question whether or not there is a reasonable basis in the record to find that Mashni is not entitled to a penny of that $200,000? Is that the issue we need to decide?
I think it's the flip side. I think it's the receiver's burden to explain to the court, first of all, what part of the appointment order authorizes him to even request fees. And then the second part of it is he has to affirmatively demonstrate, which gets to your question, it's his burden to demonstrate that all of the fees were incurred for the benefit of the estate. And then there's a further step, which is the reasonableness question. That's after he establishes his eligibility for a fee against the backdrop of the American rule.
But we're the Court of Appeals. We're not the trial court. I understand there are burdens at the trial court. We're presented here with an abuse of discretion standard. Right. We're supposed to look to a record and determine whether there's a reasonable basis for that decision. That being the standard, are we to look at the record and assess whether or not there is a reasonable basis in the record to deny Mashni every penny requested in the first and second application?
I think on this record, there isn't anything in it to justify the grant of the attorney's fees. I think the way you're framing it is the other way around. Because it's his burden, I think he has to prove and point to something in the record that establishes his affirmative ability to get fees, which they have not done. And that goes to our cross appeal.
What about the fact that you have not affirmatively established misconduct?
I think that again is in Judge Foster's ruling.
Okay, let's talk about Judge Foster's ruling. So in Mashni 1, that was a special action, right?
Yes.
Okay, so 2, 3 issues were raised. The Court of Appeals took up the issue of immunity only and did not rule on the others, right? And that goes to the language Judge Weinswag read earlier. Does that result in is that a preclusive effect on the other issues? I mean, isn't the Court of Appeals at liberty to take up one of the 3 issues raised by Mashni, leaving the others intact? And isn't that why those others came up in Mashni too?
Absolutely. It's a special action, so the court can pretty much do whatever it wants when it takes those cases. But the effect of the court's ruling was to leave Judge Foster's ruling as far as it goes to attorney's fees intact. And he denied it, and I think the record shows that misconduct was why he denied it. And so there is a finding in that order, which was never disturbed. Judge Contest probably could have, and sort of did, reconsider.
Do you need a finding of misconduct to win?
No, I don't think so.
In the second, it went back to Judge Gerlach, who assesses the fees and isn't interpreting Mashni 1 as saying you don't have any authority to disagree with anything that's been said previously. Is that right?
Well, I think what Judge Gerlach did was twofold. What ended up with that order here was he said this is moot anyways, but he goes through and talks about, he's mostly couching it in terms of reasonableness, but he also does talk about whether it benefited. He uses the phrase bankruptcy estate at times, but also the receivership estate. If you take a look, he cites receivership case law and says there's no showing of a benefit to the estate. I think that's enough. It doesn't even need to be necessarily misconduct. Misconduct doesn't benefit the estate. Really, that's ultimately the test, is the benefit to the estate. Misconduct can't benefit the estate. Fees to get fees can't benefit the estate. And then the same issue really with regard to the appeals. So it's ultimately the test is whether it benefits the estate. That's what all the cases say. In order to get fees, there has to be some, otherwise there's no limiting principle.
And
You
you have an Arizona case that says that?
So the closest thing we have in Arizona would be the Purdon case, which was the,
How do you spell Purdon?
I believe that it's Purdon, I think. It's a probate case where the court said you can't get fees for defending against claims against the estate because it benefits you personally. It doesn't seem to me much of a step to put that into a receivership context, because it's the same kind of idea where there's one person
Oh, it
who's
was
managing
estate,
an estate.
it wasn't a receivership.
No, it was not a receivership case. It was a probate case. We also cited a trust case. Again, it's a similar concept where there's one person managing things for other people. And also in that case, the Court of Appeals says there has to be some kind of benefit to the estate. So this isn't, there's no receivership case in Arizona, but there.
Was there a finding of misconduct in those cases?
No, there was not, actually. In the probate case, the person who's the estate representative largely won on appeal and only had a small amount of what had been paid out, I believe, that she was required to pay back. So no, there was no finding of misconduct. I don't think we need a finding of misconduct. I think we have one. I think that's a sufficient basis for the judges, all three of them, to reach the conclusion that the receiver shouldn't get any fees. And there's nothing, to get to our cross appeal, there is nothing in the record to support the grant of fees in this case. There's no showing of any benefit to the estate. Keep in mind that the receiver didn't even hire his lawyers until after the bankruptcy bankruptcy case was filed, and Sunnyslope had already moved to compel him to turn over the receivership property. So he hasn't had the receivership property for a very, very long time.
Counsel, I have a question for you. Back to the issue of the special action and the effect of Judge Foster's order, which your position has been that it stood even after the special action, correct?
Correct.
And so in Mashni 2, in the context of discussing mootness, the court said that in these circumstances, the Superior Court was not only authorized, but required to rule on Mashni's fee application. Was the court referencing the first and second applications? And how do we reconcile that if that issue had already been established?
Yeah, I believe it was the first and second, excuse me. But that portion of that ruling was really dedicated only to mootness, which if you look at Judge Gerlach's ruling, there's two pieces to it, and the mootness is the end of it. And so Mashni 2 really only addressed that, said, yes, you have, because he said, you know, I think that there was no benefit to the receiver estate. There's all these problems. This is clearly not reasonable. You're asking for over $400,000 for a case. How has that really benefited the receivership estate? Mashni 2 really only says, but again, Judge Gerlach went on and then said, oh, it's all moot, so I'm not going to do anything. And this court said, no, you have to do that. And that's what Judge Contest did. And she went back and she looked at all the previous orders, found them persuasive, found our objections persuasive, where we said there's no benefit to the estate, raised the reasonableness issues and everything. So I don't think Mashni 2 said much about what we're dealing with today. It expressly actually said we're expressing no merits, no view on the merits of the application. That's what Judge Contest did. And I'd like to reserve what I have left for.
All right. Thank you.
Counsel doesn't provide any basis in the record for the court to award 0 fees requested in applications 1 and 2. And Sunnyslope is taking a very narrow view of this benefit to the estate argument. Their argument is that anytime a litigant goes after a receiver and attempts to sue him personally, that his defense of that suddenly becomes a personal interest that is totally divorced from the receivership estate. But what they're ignoring is that the receiver was trying to be discharged from his duties as the receiver, and he had no choice but to defend himself. And he was defending his official conduct under the appointing order. And
So is he entitled to fees regardless of the allegations of misconduct?
there has been no finding of misconduct. There has only been allegations.
But the court can consider, back to the example I gave you, if he had agreed to sell property for $100 that was worth $1 million, the court wouldn't abuse its discretion by saying, you're not going to give me any fees for that, even though you're acting within the scope of your duties, you get zero for that.
For that sale that the court found
Right.
unreasonable.
But, I mean, couldn't that be what the court is essentially saying with what, if you go through what Judge Foster, what Judge Gerlach, and Judge Contes are all suggesting, that none of what you did benefited the estate?
Well, that's not what Judge Contes said in her order. She could have said that. She pointed to some language about reasonableness, but when you look at her decision, she expressly noted the Sunnyslope's argument that Mashni 1 never overturned the denial of the fees and stated that as an express reason, and then only denied those 2 fee applications. So I don't think there's any finding in the record that.
But that doesn't make a lot of sense when you look at it from the standpoint of what Judge Gerlach is doing on remand. There's clearly Judge Gerlach isn't saying there was some preclusive effect that I can't revisit what Judge Foster said. He's actually making an assessment of whether fees should be awarded. So it seems like just the reliance on the discussion from Judge Foster would not necessarily be improper. It's not out of the realm of what she should consider.
Well, because this court overturned the immunity ruling and the only discussion in Judge Foster's order was the immunity ruling, I don't think it would be proper to rely on that language because there's no valid finding in the court of any misconduct.
Could we find that there was an implicit finding based on the record?
I don't think so, given this court's finding in Mashni 1, holding that the receiver acted within the scope of his authority. And I know both parties agree that the Clark Treatise is authoritative, and Section 642C of Clark directly addresses the question of when a receiver is sued for engaging in his official conduct within the scope of the appointing order, he shouldn't be personally liable for those defense costs. And also from a policy perspective, I think it would have a significant chilling effect on the willingness of people to serve as court-appointed receivers if they could be appointed and then engage in conduct that's authorized by that appointing court and sued for engaging in that conduct, but then have to personally pay the costs of defending that official conduct, even when a court finds that they acted within the scope of their authority.
But there's kind of 2 separate questions, and that goes to the example. If you've done something that's within the scope, but it's just clearly not benefiting the estate, you're immune from being sued, but that doesn't necessarily guarantee that you're going to obtain fees in defending what you did. You're saying you should automatically be entitled to have fees for defending what you did, even though it didn't benefit the estate?
I think it depends on the circumstances, but where your conduct is authorized under the appointing order and where you have an appointing order that governs fees like ours does here, I think, yes, he should be entitled to those fees that are necessary and reasonable in discharging his duties under the appointing order.
But isn't one of the central, if not centerpiece, arguments in your brief is that Judge Contes found, I think the word was persuasive, the denial of fees by Foster, right?
Right.
And if that wasn't error, meaning a special action, we didn't reverse it, So what's to say that she can't look at it and even find it persuasive? Then how do you win?
Well, because even if the court didn't technically reverse that finding was still tied to the immunity finding, and then the receiver renewed his request for discharge and for fees, and the Superior Court decided to consider and rule on those in the mootness order. And then this court in Mashni too directed the court to consider and rule on those fee applications.
Counsel, your time's up. Thank you.
Thank you.
Just a few brief points. In Judge Foster's order, he says, the evidence indicates that the receiver undertook certain agreements regarding the sale and operation of the property that inured to his benefit. And he says that the receiver did not execute faithfully the order that appointed him. So I think those are findings of misconduct. Again, he's immune, but still, the misconduct justifies the denial of fees entirely. As far as the idea that the receiver had no choice but to defend himself, that's a position a lot of defendants find themselves in. And it goes back to my original point, which is they need to show they're eligible for these fees, and they have not done that. They've tried to shift the burden to us to prove that they're not entitled to fees, but that's not the way it works. And the Hawaii Ventures case, follow-up to finish that point, that he could have asked for the appointment order to have been amended to allow him to defend himself, because the appointment order does not say that he can do that. So they don't even get past that first stage. The Hawaii Ventures case that both parties have talked about in great detail, there is, I think, supports the point that immunity and fees are totally separate. If the pin site 751 or 754 says when the receiver is engaged in misconduct, even if he's immune from suit, he can't get fees.
Thank you, counsel. Counsel, we thank you for your arguments. This matter is now under advisement, and we will issue a written order in due course. We're going to take a recess to set up the courtroom for the next argument.